It's important to recognize that the drafters of the Constitution distinguished between the rights of what they called citizens and what they called persons, regardless of citizenship. Official citizens have certain rights, but all people have most rights, citizen or not. Several sections of the Constitution make it clear that the framers carefully differentiated between the word citizen and person. And I say this because some people say that the Constitution doesn't apply to non-citizens. While it is quite clear this is not the case. So for instance, when Article 1, Section 2 says, "No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States," it's saying that citizen and person are different concepts in the constitutional language. Similarly, Article 2, Section 5 distinguishes by saying no person except a natural-born citizen or citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. So when the Constitution says things like the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated, this applies to all persons in the United States, not just citizens. This is the constitutional framework for all our laws. You know, I noticed that according to polls, only about 28% of Americans have read the whole Constitution. I hope we can add you to that number if you're not there already. So while I've specified certain sections that I want to make sure you look at, it's always great to go through the whole thing. It's not all that long. Now, under the constitutional framework, we have federal or national laws. The most important one for us is the 1964 Civil Rights Act. Despite the passages of the 13th, 14th, and 15th Amendments after the Civil War, blacks were still denied many rights, and the U.S. evolved into essentially an apartheid society. Apartheid meaning blacks were often separated from whites in housing, in education, in recreation, in transportation, and public accommodations of all kinds. The 1964 Civil Rights Act, which came after the 1956 famous Brown versus Board of Education decision, was the beginning of great practical changes in the United States. It's difficult to overestimate its impact. Brown versus Board of Education declared that apartheid concept of separate but equal to be unconstitutional. And the 1964 Act prohibited discrimination on a wide variety of categories. This law made discrimination over voting, in education, in the workplace, or public accommodations, meaning the private sector, illegal if it was based on race, color, religion, sex, or national origin. Those are often called protected groups or classes. Discrimination on the basis of those characteristics violates federal law. The legislation also created the Equal Employment Opportunity Commission to enforce the law. And the 1988-89 amendments to the Civil Rights Act added disability and age to the protected classifications. There are other forms of discrimination that may be wrong or unfair or unprofessional, and most discrimination not based on performance is bad management. But discrimination against these protected classes is illegal under federal law. And that means the government can charge you with breaking a federal law. In addition to federal laws, there may be state or local laws that are applicable to a particular agency or level of government. And the fact that the California Constitution prohibits discrimination means that California law enforcement authorities police this and not just federal agencies. Additionally, local municipalities may have anti-discrimination ordinances or policies. The ADA, or Americans with Disabilities Act, is another complex series of laws that protects the rights of disabled people. It requires agencies to undertake actions and incur costs that allow a disabled person to work, as long as those actions are deemed to be a reasonable accommodation, which is subject to court interpretation. It's critical that all public managers understand the basics of this law, as they will be held accountable. And defining what is reasonable accommodation is not always clear. The ADA can be challenging to implement because the definition of disabilities has expanded tremendously. It's a good thing that we as a nation are doing, but it presents challenges to the organization which provides the accommodations, and it can also cause issues among employees. The Equal Employment Opportunity Commission, or EEOC, is the government agency charged with implementing our non-discrimination laws. These laws address issues of hiring, firing, promotions, and other resource actions, but they also apply to interactions with vendors and clients. Now, you might complain about all these different laws and ask, why can't we just have one law that says you can't discriminate against anyone based on their personal characteristics? That's one way, maybe a good way, but many people and groups have resisted that kind of blanket focus by citing individual freedom to make decisions based on what they think is best. And the result is that in the private sector, I can fire you if I don't like you, but not because you're a member of a protected group. The public sector is protected by requirements for due process from such firings.